Hello everyone, it's Wayne Jones, the course coordinator for Australian Employment Law. Just picking up where I left off at the end of chapter 5 in the textbook and talking about some of the interesting points which come up in chapter 6 in our textbook, Stewart's Guide to Employment Law. This is the chapter which deals with the terms of the employment contract. So there's a little bit of overlap between this chapter and chapter 5. But on this occasion, we're talking about some of the terms that are going to appear in employment contracts. And I want to reiterate again, don't overthink it. It's an employment contract, so it is still a contract, which means that a lot of the terms and conditions that you would expect in a contract are meant to appear here as well. There's going to be some different things because it is an employment agreement and not, say, a contract for the purchase of a car. But do understand that the provisions of the contract are still very much a contract. So the terminology is going to be the same as for any other business contract. And one of the first terms that we see is this concept of whether or not the contract needs to be in writing or not. Now, there are very few contracts where that is the situation, predominantly the one that's usually referred to as a contract for the sale of an interest in land. But this contract can be written, can be by text, it can be email these days, it can be notes, phone calls, conversations, or it could be a combination of all of those things. But the big issue when you get all of those bits and pieces together is, first and foremost, did you have an agreement, and was there an intention to bind the parties to all of those bits and pieces? Now, the textbook refers you to this concept of express terms, because we're going to talk about some other terms and conditions. We're going to talk about some conditions which might be implied, for example. But express terms are those things which the parties either agree to, or they think they've agreed to quite specifically. One of the points that the authors make in the textbook that I think is really important is that not reading the contract is your problem, that the courts won't be sympathetic if you come along later and say, well, look, there was a contract, there do appear to be some quite express terms in that agreement, but look, I didn't read them, so I don't think they should apply to me. I'll mention to you again a little later on that these types of contract are all, like most contracts, are generally construed from an objective point of view, not a subjective point of view, but objective. So that means that the court is trying to determine what the average person would think that the terms mean. And before we even get into implied terms, the first place that the courts will stop is to look at express terms within the contract. So it's important to determine what those express terms are. Now, I mentioned, I'll just go back a slide, I mentioned before things in writing, texts, emails, etc. One point that needs to be made is that not every pre-contract discussion is going to throw up something where it's objectively able to be said that, well, the parties must have thought that that was going to be part of the contract. So, in other words, was it a promise that the parties should feel that they are bound to? And the textbook makes the point very well that the clearer that the express term is, the more likely it's going to be enforced. The more vague it is, the less likely it'll be seen as a promise. So just bear that in mind, that all those bits and pieces make up the express term of a contract, but not all of them are going to be binding. Now, I had a look at some of the agreements at the university today, just to see how often these entire agreement clauses come up, and I'd have to say quite a bit. And the thinking behind this entire agreement clause is that the party that's likely to be bound, or the person, in this case the employer who's putting the contract together, generally likes to be pretty clear on what it is they're being bound to. Now, just as an aside, you'll often find this in franchise agreements, in lease agreements, particularly leases in shopping centres, that sort of thing, where there'll be a clause that says something to the effect that this contract represents the entire agreement between the parties. Now, it often goes on and says something like, and any other representations that have been made should not be relied upon, and you should bring them to the attention of the, maybe the shopping centre manager or something rather before you sign this agreement, that sort of thing. So you try to draw a corral around the terms and conditions which both of the parties are agreeable to be bound by. There is a case that's referred to, and that's the JP Morgan case, where the job description that was given prior to entering into the contract was taken to be part of the agreement, even though it had one of these clauses. And I think that's a good point to make. You'll see also reference to some other occasions when even having a condition like this in the contract doesn't override the truth. So you can have this clause, it does put the proponent of the other condition on the back foot a bit because they've got to do the proving, but it's not impossible even in the face of this clause. It doesn't slam the door shut entirely. So something left out by a mistake, a misrepresentation, or the textbook refers to a case involving a Victorian work cover where there was said to be a promise not to enforce certain parts of the agreement. And even in the face of a whole of agreement clause, that was still able to be applied. If any of you have done statutory interpretation, these terms won't be new to you. So you'll know that in interpretation, well, first things first, the courts take a very objective view. They look at the words that appear there. In statutory interpretation, we talk about giving those words the literal meaning. And certainly in this case, looking at an employment contract, the courts do look at the actual words that are being used. In the case of an ambiguity, the courts may look at surrounding information. And again, you've probably seen that in statutory interpretation. We'd refer to that as extrinsic material. So you try and find the material from within the contract itself. If you can't find the meaning from looking at in the contract, you may look at extrinsic material. So to resolve an ambiguity, you might go outside. The comment is made also that these ambiguities are usually resolved in favour of the employee, probably as a matter of public policy, but I would question whether that happens all the time. I think you'd have to look at the circumstances of the case. And again, like statutory interpretation, looking at what happened after the event doesn't really tell you objectively what the parties were agreeing to when the contract was entered into. So what happened afterwards is of limited value. In Stewart's Guide, they do refer to a case where it assisted the court to identify the subject matter, namely the duties that the person would be performing. But as a general proposition, what happened after the contract is signed doesn't assist in interpretation all the time. All right. Now, there are implied terms that get a mention in the text. Look, I think they're of limited value, but let's just have a quick look at them anyway. Terms which might be implied in fact, terms which are implied by custom and practice, and terms which are implied by law. So let's have a quick look at them. Implied in fact, the terminology that's used are words like so obvious that it goes without saying and is necessary for the effective operation of the contract. I, in fact, had a look at a much earlier case, not one that's mentioned in your textbook, and it referred to a vessel being tied up to a port, tied up in port, and when the tide went out, the vessel sat down hard on some rocks which were underneath the dock. And the court said in that case, look, would have to be implied in fact that there'd be a condition in the contract that you take good care of the vessel and you would not put it in a situation where it would be damaged. And because the owner of the dock knew that that there were rocks and what have you underneath the water at that point, they were held to be liable. So the court said, look, it's so obvious that when someone docks a vessel at your dock, they're expecting that you look after it. So limited application here, but have a look at the case of Byrne Australian Airlines. Custom and practice has to be not contrary to the specific terms and conditions in the contract, and good luck finding an example. The textbook refers to the case with the redundancy, where it was the usual situation within the employer that last on was first off. So in the case of a redundancy, the person who was most recently hired would go. I couldn't really find any other examples of it. I think they're a bit thin on the ground, but custom and practice does exist, but it needs to be really well known within the industry, so much so that it's not too much of a stretch to say everybody who was involved in the contract is presumed to have included those terms in the agreement. Implied by law, these are the only ones that I saw some evidence of still being in use, and they were those default rules developed by the common law, and the two that we've spoken of previously were in the case where the person's pay has not been spelled out, they'll receive a reasonable remuneration for their work, and in the case where there is no end point for the contract of employment, the courts will infer that reasonable notice will be given. And I want to make one comment here regarding what I might call a dry gully. There was an interesting case that gets a mention in the text called Commonwealth Bank against Barker. There'd been a line of authorities developing in Australia that said there's an implied obligation to maintain mutual trust and confidence. Doesn't sound much, but these were the cases which said that a person could receive additional damages where a contract was broken in circumstances where their reputation was harmed in some way. Anyway, the High Court's rejected that concept, but have a look at it if it takes your interest. So implied by law, though, mainly around reasonable pay and reasonable notice. And those 2 points I'll just make again. You can't imply any of these in the face of a specific term in the contract, so it's no good saying, well, the contract says this, but I think there's an implied term, because you're stuck with what the contract says. And you have to be able to argue that they were necessary, that the implied term is necessary for the effective operation of the agreement. In other words, the agreement just won't work so well without it. I find this pretty interesting. Management policies and procedures. Have a good read of the commentary on management policies and procedures. A couple of points from me though. The enforceability of management policies and procedures may or may not rely on the contract. So certainly the contract itself, when you sign up, one of the terms and conditions may well be that you'll agree to abide by all of the terms and conditions that the management pass from time to time. So that'll be important, otherwise you're just stuck with the ones that were there on the day that you signed on. So it could be in the contract to that extent. But the other argument, and the one that I think probably gets better traction, is to simply say that most policies, if they do the work that they're supposed to do, really amount to reasonable directions. So an employer is entitled to give lawful instructions under a general, and there is a general duty on the employee to obey. So I would think that that's a really strong underpinning for management policies and procedures without having to say that they need to appear in the contract. But nevertheless, there's argument for both. Workplace health and safety policies generally have the force of law, so the legislation in your particular state will say that certain things need to happen, and they'll usually be brought to the fore through policies and procedures. Think, for example, of policies and procedures in the workplace regarding the use of motor vehicles or smoking in the workplace, those sorts of things. Policies and procedures generally promote a sense of fairness and process in the workplace, which are important because they take away that arbitrary nature of decision making. Note the comments also that management policies and procedures may be just as binding on the employer as they are binding on the employee. The case that got the most mention that I think is worth a look here is, again, that Goldman Sachs and Nikolic case. I find that one interesting because what was happening there was an argument around what the company did and what the company said it would do. So there were plenty of representations as to what their values and culture were, but the argument was they weren't living up to them. So just be aware of that case and have a look at it. Just in relation to variation of terms, the main points to be made, I think, are these. I keep saying it over and over again: a contract, a contract, a contract. It's still a contract. So once you've got that binding agreement, the parties have had a meeting of the minds, they've entered into the agreement, there's consideration, etc. It's a binding agreement. And so no surprise when I say you can't make unilateral changes. Particularly to things like roles and responsibilities, wages, hours, except of course to improve the situation. And likewise, if the contract itself talked about the prospect of changes in the future, then although they were, as long as they are not entirely unreasonable changes, if they're, for example, incremental changes or requirements to do work slightly differently, what have you, and then provided there's some consultation, your textbook makes the point, of course, that most agreements these days do refer to consultation for any changes in the workplace. As long as that happens and it's not a unilateral change being imposed, then you should be able to make some variations to the contract. But if it's done badly, two things can flow from it. One is the employee may terminate the contract and sue for damages, or demand that the original terms be maintained. So there is flexibility, there's room for flexibility, but asking too much is asking too much. And the good example that was given in the text was a requirement to move around. I can see that. University contracts, for example, may make an allowance for asking people to move around within the workplace and take up different roles. Entirely different, though, to say in a multi-campus environment, we'd like you to pack up and move from Rockhampton to Cairns, or we'd like you to pack up and move from Cairns to Noosa, something like that. That would really require agreement, could not be done unilaterally, certainly would require some consultation. The effect of awards and agreements, very interesting. Don't get too bamboozled by this. We're not talking about hierarchy, we're talking about whether the awards and agreements become bound into and become terms and conditions of the contract. So just put aside for a moment which one takes priority and just think about whether awards and agreements could be bound into the terms of the written contract. When you think about it, the nature of awards and agreements is they're going to be changing quite often. They are a very separate instrument. Very rarely, if ever, and I couldn't find a case, but I don't think you're going to find that a court would infer that awards and agreements are part of the contract. They're just very different things. They're two separate instruments. And when you think about it, how they are enforced varies greatly. So awards and agreements are varied through the processes which are set out in the Fair Work Act, and they really can't be changed. But some things in your contract, if there's a breach of your contract, are likely to be enforced a very different way. So just by way of an example, for instance, a contract at the university might have an allowance for some negotiation as you get towards the end of the contract, so many months out, to talk about whether it will be renewed. Now, nothing like that appears in the award or the agreement. It's very much a contract term, and if you want to enforce that, you'll have to go to the civil court. But if you want to enforce a term of the award or agreement, you will go to Fair Work, or in some cases to the court. Have a look at the case of Solomon and UTS. If you have a look for him on Ostley, you'll see that he's involved in a lot of litigation, and but you're looking at one of his earliest cases, which I think off the top of my head is about 2008. But have a look at Solomon and UTS. It's the one that's mentioned in your text. And also remember that so far as national employment standards are concerned, the contract can only provide more favourable terms. It can't shave anything off the national employment standards. It can make some allowance for specific items like cashing in holidays and balancing out hours and time worked over a period of time. But generally speaking, the proposition is that your contract terms can't vary the national employment standards. Look, the textbook refers to unfair contracts legislation, but I don't know that it provides a lot of guidance for us. Only very limited effect on employment contracts. For example, Section 20, the person must be suffering under a very special disability before they can rely on that term. That was the one that dealt with unconscionable conduct. And by the way, these sections are the sections in the consumer legislation, not in the Fair Work Act. And Section 21 only dealt with service contracts and then only in very special circumstances. Look, have a look to round out the chapter, but as I said, not a lot of use in the employment contract sphere. Look, that's my comments on Chapter 6. Quite interesting, I thought, both of the two of them combined, Chapter 5 and Chapter 6, about the contract, how the contracts are formed, and then this week, this chapter dealing with what terms and conditions you would expect to see in a contract. But have a look through both of those, and next week we'll talk about the national employment standards and awards.